Major immigration changes under the Secure America Act, August 2025. As of August 2025, U.S. immigration has entered a new era, one that deeply impacts every immigrant, sponsor, and applicant currently in the system. The recently enacted Secure America Act, H.R. 1, a cornerstone of the Trump administration's immigration agenda, marks a sweeping overhaul of how green cards, visas, and citizenship applications are reviewed, processed, and approved. This isn't a minor adjustment. It's a complete reset of how the system works. If you're a green card holder, an applicant, or someone sponsoring a family member, this urgent update is for you. Let's explore how the Secure America Act is already reshaping immigration and what you must do to protect your future in the U.S. What is the Secure America Act? Officially signed into law earlier this year, the Secure America Act, also referred to as H.R. 1, aims to centralize control, eliminate loopholes, and tighten oversight across all immigration functions. It's not just about updating a few forms or rules. It's about creating an entirely new infrastructure for enforcement and adjudication. Key pillars of the Act include stricter security screenings, centralized decision-making authority, wider data sharing among government agencies, limitations on officer discretion, reduced access to public benefits. Even long-term U.S. residents are now subject to new scrutiny, whether they're renewing a green card, applying for a visa, adjusting their status, or seeking naturalization. What's already in effect since August 1, 2025? The law's enforcement rollout began on August 1, 2025, and continues to phase in over the month. Here are the key changes already active. Fee waivers are now severely restricted. Before August 1st, fee waivers were commonly granted for applicants with low income. Now, waivers are almost impossible to obtain unless the applicant is well below the federal poverty level. DACA recipients and undocumented immigrants are specifically excluded from waiver eligibility. If your request is denied, your application could be outright rejected. There are no automatic second chances, making preparation and eligibility verification critical before you file. Biometrics now required for nearly every filing. Biometric submission, fingerprints, facial scans, and digital photos is now mandatory for nearly all immigration forms, including green card renewals, citizenship applications, work permit filings, some family-based petitions. Even U.S. citizen sponsors may now be required to submit biometrics for identity and background verification. This data is shared with agencies such as the FBI, DHS, and SSA, making any past unauthorized work or fraud much easier to trace. Nationwide rescreening for green card renewals. Perhaps the most alarming change is how green card renewals are now treated. Previously, Form I-90 renewals were routine. But now, renewing a green card is equivalent to filing a brand new application. This means full background checks, detailed tax record audits, employment and work history verification, checks for prior public benefit usage. Any inconsistency or red flag, no matter how minor, can lead to delays, denials, or even investigations. Cross-agency data sharing is now standard. USCIS no longer reviews your application in isolation. Your case is now automatically cross-checked with multiple databases, including IRS, Social Security Administration, DMV, CBP, and ICE. This means your tax history, driver's license data, work income, and even health benefit usage are now analyzed together. Mismatches equals red flags. DMV checks and identity verification. Starting August 21st, USCIS will begin automatically checking your identity and address against DMV databases. If your driver's license doesn't match the address listed on your application, your case could be flagged or delayed. The new public charge rule, stricter than ever. The public charge rule, used to deny applicants likely to depend on government aid, has returned with greater force. To qualify for most immigration benefits now, you must prove complete financial independence. Applicants with a history of using programs like SNAP, food stamps, Medicaid, Section 8 housing, are now at high risk of denial, even if their usage was brief or years ago. Unenrolling from benefits now won't erase your history. The law evaluates your past behavior. Affidavit of support, zero tolerance for errors. Sponsors now face increased scrutiny too. If you're submitting Form I, 864 to support a family member. Your income must exceed minimum thresholds. You must include full tax returns, pay stubs, and job verification letters. Bank statements must match your declared income. Inconsistent or vague documents are now one of the top reasons for denials, and under this law, USCIS is granting no flexibility. Who's most at risk right now? If you're in any of the following categories, your case needs urgent review. Applicants with a criminal record. Even if your charges were dismissed or sealed, USCIS now conducts deeper record checks and may flag your case. People who used public benefits. Even short-term food or health aid can now result in a denial. Applicants with unfiled or incorrect tax records. Your income is now verified directly with the IRS. Those who worked off the books. Undocumented employment is easier to trace via cross-agency data sharing. Who might actually benefit? Not all news is bad. If you have no criminal history, filed taxes accurately, never used government aid, have strong financial records, then your application might actually move faster under the new centralized, data-driven system. In addition, employers filing compliant H-1B, EB-2, or EB-3 petitions may face fewer RFEs. Family-based sponsors with clean and clear documentation may experience faster processing. What you must now include in every application. To improve your chances of approval, every applicant should prepare a stronger evidence package than ever before. Required personal documents. Valid passports, current and expired. Previous USCIS approvals and notices. Copies of green card or visa, even expired. Financial evidence. 3 years of tax returns, with W-2s or 1099s. 6 months of pay stubs. Employment letters verifying job title, income, and duration. Bank statements matching declared income. Lease agreements or mortgage statements. Utility bills to show address stability. Background checks. FBI identity history summary for anyone with prior legal issues. Police clearance certificates. Smart strategies to protect your case. Here's what you can do right now to prepare. 1. Fix your tax record. If you haven't filed or filed incorrectly, work with a licensed tax preparer to correct it. Save all IRS transcripts and receipts. 2. Exit public benefits. If you're currently receiving aid, begin transitioning to employer-based or private alternatives. Keep records showing when you left the program. 3. Strengthen financial evidence. Your sponsor should ensure that all bank deposits match job income. Avoid cash deposits or untraceable transfers. 4. Clear legal records. Request your FBI background report. If there are past arrests or charges, consult a qualified immigration attorney immediately. Final thoughts. The reset has already begun. 2025 is a turning point for U.S. immigration policy. The Secure America Act has fundamentally changed the process for everyone. You're no longer dealing with just USCIS. You're dealing with a web of interconnected government agencies, stricter laws, and nearly zero room for mistakes. If your records are clean and organized, your case may move quickly. But if your history is inconsistent or incomplete, you must act now. Stay informed, get prepared, and most importantly, don't wait. If this breakdown helped you, be sure to like, subscribe, and turn on notifications so you don't miss our next critical update. Thanks for watching USA Alert Zone.